Hello, welcome to today's immigration tidbit. Well, we've done a few videos on Padilla versus Kentucky, so I'd like to take a different angle to further explain the situation because unfortunately there's a lot of people who plead guilty to crimes who only find themselves on the other side being an aggravated felon and being deported for the rest of their lives. So when is what the judge says enough or not enough? So, for example, if you're in criminal court and the judge says something to the effect, you are not a citizen of the United States. By pleading guilty to this, you may be deported, you may not be able to become a U.S. citizen, and you may be excluded from the United States. Is that enough? And the answer is no. That doesn't tell the truth. First of all, a lot of times judges will say excluded from the US, but exclusion is an immigration term that has ended nearly 20 years ago or more. People are not excluded. They're deported or they're inadmissible, but not excluded. So that doesn't even apply to current law. And the fact the judge would say it is a bit confusing because is the judge referring to an immigration term excluded, or is the judge referring to um, just the normal term of not being able to enter the U.S.? So that's confusing. As far as may not uh, be able to enter the U.S. or may be deported, those are not true. If the person is pleading to something that makes them an aggravated felon, it's not may. It's you will be deported and you will never be able to re enter the US. So that's a whole lot different than you may be deported and you may not be able to enter the US. So you see, words have a great deal of effect here, in that the judge is uh, essentially giving an immigration advisal for someone who pleads to something like, a 3-month battery sentence or a misdemeanor or something that is not a serious aggravated felony crime. So in that respect, if the judge does something to that effect, and if the other side argues, well, you were given your advisals, you'll be able to argue you weren't. They weren't full and complete. They weren't accurate. In fact, they were inaccurate and gave a completely different picture. If somebody thinks they pleaded something and that they might be deported, they'll roll the dice. They'll see what happens and they'll hope for the best. But if someone has said that by playing to that, they will be deported and they will never be able to come back, there's a whole different mindset as to whether or not they should take the plea, or whether they should fight it in court, or whether they should seek the advice of an immigration attorney familiar with it to let them know what exactly that means. The plea itself has to be knowing and voluntary. Those are not just words put out on a book or in the law. It's something that has meaning. It's something that has to make sense so that the person who is saying, I'm guilty, knows exactly what the consequences will be should they make that particular plea. For someone who's not a citizen and they plead guilty to a crime, it's not just about the criminal sentence, because that's just the first part. Once that's done, they'll be transferred to immigration detention in order to basically fight deportation hearings. And if they're an aggravated felon, it becomes much more difficult to try to win. So, given that, the judge's advisals are very important as to whether it forms a basis for you to use Padilla versus Kentucky and try to get the crime vacated or reduced so that you're not considered an aggravated felon. Okay.